The Ira Smith team hopes that you and your family are healthy, safe, and secure during this coronavirus pandemic. Ira Smith Trustee and Receiver Inc. has been fully operational throughout. We're doing all our meetings and consultations and filings by telephone, FaceTime, Zoom meeting, conference call. So if you have any questions whatsoever, you can shoot either Brandon or myself an email. You can give either of us a phone call. Today, Brandon wrote a blog about two totally unrelated bankruptcy process matters. The first one is an update on the Hertz Rent-A-Car U.S. Chapter 11 bankruptcy case. The second one is about a recent decision from the Court of Appeal for Ontario, but both of them deal with the bankruptcy process, equally attributable to either the US or Canada. So, I hope you can watch this video until the end. I know you will get value. First matter is an update to Brandon's blog that he wrote last week called How Hertz Teaches Us Modern and Risky Rules of Business Bankruptcy in Canada and the USA. And in that, he talked about the craziness going on with the Hertz common shares in the stock market. He reported that legendary investor Carl Icahn sold his entire holdings in Hertz for about 72 cents a share, took a massive loss. The Hertz stock had dipped as low as about 40 cents, and then it started trading higher and higher, and it hit over $5. As of today, it's trading around the $1.90 level. But it is just unbelievable that a company going through Chapter 11 bankruptcy proceedings should have value for its shares. And this is all while the New York Stock Exchange decided that it was going to delist Hertz. Now, Hertz has appealed that decision. The reason it's crazy is because in a Chapter 11 bankruptcy case, if successful, the creditors take a large discount in what's owed to them in order for the restructuring to be successful. The shareholders essentially get wiped out, and the share value reflects that. But in this case, the shares have been trading higher and higher. They've been attributed value. Well, Hertz noticed this. So last Friday, they went to court with a motion for approval to enter into an agreement with a broker to issue hundreds of thousands of unissued common stock in order to raise $1 billion. And last Monday, June 15th, the U.S. Bankruptcy Court in Delaware approved it. Now, Hertz went to court with clean hands. They told the judge that they can't explain this share activity. The shares, they believe, can be sold. In any prospectus, they will warn every potential shareholder that they believe these Hertz shares being issued may very well one day prove to be worthless. They told the court that this sale of shares is preferable to getting expensive debtor in possession financing. There will be no covenants whatsoever with a share sale, so there's no opportunity for Hertz to break the covenants. There will be no interest costs. There will be no requirement to issue dividends. And the court approved it. Now, this is totally wacky. Who is going to buy shares in a company when they're told it's worthless? but the market has shown that there are investors willing to do it. The only thing we can think of is that investors think there is going to be active trading and they will be able to trade their shares for a profit, and that when the music stops, they will not be the one left without a chair. It's totally crazy, but we're dying to see what happens. We will do an update when that result of the share sale is known. So that was the first bankruptcy process matter. The second bankruptcy process matter, which really doesn't have anything to do at all with a bankruptcy case, but it does have to do with rehabilitation, which is one of the aims of the Bankruptcy and Insolvency Act in Canada, is the financial rehabilitation of the honest but unfortunate debtor. What this case is a decision released on June 11th from the Court of Appeal for Ontario. And it was an appeal from an order made for restitution by a judge in a criminal matter. Here we had a 32-year-old man with a high school education, and as they say in the media, he was known to authorities. He had a very long rap sheet. He was caught and found guilty of breaking and entering and robbery in many businesses. There were about 10 businesses in all. I believe he pleaded to a few of those break-and-enters and robberies. The judge gave him 4.5-year prison sentence and as well a $15,000 restitution order. It was the restitution order that was appealed. The appeal was on the basis that the judge did not take into account whether this man ever had the ability to repay that restitution order, and said to the Court of Appeal that is not proper because it did not take into account the rehabilitative nature of a restitution order. The Court of Appeal for Ontario found that the judge properly calculated the restitution, but did not take into account the criminal's ability to ever pay that restitution order. So the Court of Appeal agreed with the criminal's lawyers and vacated the restitution order. And it was very interesting. The Court of Appeal for Ontario specifically stated that the restitution order of $15,000, this criminal would never be able to pay. And if he filed for bankruptcy, restitution order is one of the debts under Section 178 of the Bankruptcy and Insolvency Act that can never be discharged with a discharge from bankruptcy. And therefore, this restitution order, and any restitution order, could be a life sentence for someone who could not repay it. And a restitution order cannot be a life sentence. It has to be rehabilitative in nature. So the Court of Appeal for Ontario looked at the rehabilitative aspects of why restitution orders are made, looked at the Bankruptcy and Insolvency Act, whose aim is financial rehabilitation of the honest but unfortunate debtor, and vacated the restitution order. So those are two interesting bankruptcy process cases that you do not see every day, and they are equally applicable both in Canada and the United States. So I hope you enjoyed the video. I hope you found it useful and informative. I want to assure you that Ira Smith Trustee and Receiver Inc. is fully operational. We can answer any questions you may have about this blog or about anything at all. So feel free to reach out to either Brandon Smith or myself, shoot us a message, give us a phone call. We would love to hear from you. Be safe, be healthy, and I hope that you and your family remain healthy during this coronavirus pandemic.